Exceptions to the hearsay rule. Common law exceptions to the hearsay rule. So exceptions to the hearsay rule are due to necessity and reliability, which is set in stone. So that's banned in R 1995. And courts should not attempt to ad hoc exceptions, so just make it on the spot, to the rule. So this is the legislator's job. The principal common law exceptions to hearsay rule are as follows. So you've got res gestae exceptions, and out-of-court statements made by persons since deceased, and statements in public documents and admissions. And we'll talk about these last two in the next slide. So the res gestae exception. So from the last lecture, whereby if a narrative is so contemporaneous to events, the pressure of events guarantees its reliability, it is an exception to the hearsay rule. So note that reliability is crucial. Strict contemporaneity or time is not so much, and that's Andrews 1987. The rationale of exceptions is statements made under pressure of events are unlikely to be concocted, therefore sufficiently reliable to be admitted. The exception is likely inappropriate where a bystander is making statements to events, though note, Tepper and R 1952, where a hearsay statement of a bystander excluded only due to insufficient contemporaneity. So if it was more contemporaneous, it might be. But then again, note that it's just speculative. And exception is also likely inappropriate where a statement made in the circumstances of pressure did not relate to those circumstances. And it's R. Plevic, 1995. Though res gestae should not be seen as a general doctrine to permit evidence surrounding events. It's very wrong to do that. And also, now we go to out-of-court statements by persons since deceased, so people who have died since. In particular, statements against their interest may be admitted, as long as, when made, the statement was knowingly made against the party's pecuniary, so monetary interest, which is a guarantee for reliability. Similarly, admissions by third parties for civil liability may be admitted into this category, though this logic hasn't been admitted for third-party admission of criminal liability. Of course, third-party criminal confessions may be tendered as relevant prior inconsistent statements, but not as hearsay, in this question of law reserve number 3 of 1997. Now, the Uniform Act section 65.7 extends the common law to cover penal or punishable interests, and that's Uniform Act section 65.7, and similarly provides for third-party confessions, and that's Uniform Act section 65.8. Statements in the course of duty are normally contended as documentary evidence, but where there is clear duty to report, observe, and report facts, has done so and subsequently died, there is a guarantee of reliability which gives rise to this exception, also accepted in Uniform Act section 65.2a. Now, last of all, you got dying declarations, which are admitted at common law where a per victim is subject to murder or manslaughter and hopeless or settled expectations of death. Even if these requirements aren't met, if it was made under the pressure of the events, res gestae may still apply to make it admissible. So that was very contemporaneous. Now we go to statements in public documents and admissions in civil cases. So statements in public documents which are considered sufficiently reliable if they are open to public inspection, created for public use, and created by persons with the duty to inquire or record. The admissions in civil cases, also known as the confessions in criminal cases. Now, any statement adverse to the makers in the proceeding they are party to is sufficient to make the statement admissible under this exception to the hearsay rule. This includes any statements made prior to committing the events in issue. Note these informal admissions are only evidentiary weight rather than as binding formal admissions are pre-trial in civil, so that's Supreme Court Rule 156, and Criminal Evidence Act 1929 SA Section 34, and Uniform Evidence Act Section 184. Justification for accepting informal admissions is their reliability, in that they are unlikely to be lightly made. For obvious reasons, admissions coerced from the accused may be excluded due to public policy reasons, because of coercion. And admissions implicit in conduct, so for example running away from the scene, though likely not excluded as hearsay at all, may be questioned under relevance as the party could flee a jurisdiction for a number of other reasons, and also they could lie for a number of reasons unconnected with the crime. Silence in face of allegations may be admission in a civil case, though courts are reluctant to permit this interference unless it is obvious, and that's Thatcher and Charles 1961. The silence in face of allegations in a criminal case can give no rise to adverse inference, and the accused has a right to remain silent, and that's Uniform Act Section 89. Admissions of fact must be within the personal knowledge of the party to be admissible in order to establish reliability for criminal trials, and as Comptroller of Customs in Western Electric, 1966. Now, in civil cases, the party may not need to have personal knowledge of admitted facts, and lack of knowledge only goes towards evidentiary weight of admission, as Lustre Hosiery in New York 1935. Now, obviously, the witness who gives evidence the admission was made must have first-hand knowledge of making it, as Uniform Act Section 82. Now, where there are self-serving statements in their interest alongside statements against their interest, related self-serving statements can be admitted in the parties favoured in the exception of hearsay, and that's Spence and Damasi 1988. Self-serving statements may be admitted to which it is necessary to refer to in order to understand the admission. That's Uniform Act Section 81. Admissions are only admissible against parties making it. So in vicarious admissions, that is admissions against a third party, it is inadmissible, though a person may have authority to make the admission on behalf of another. Now, in civil cases, statements by partners or the predecessors can bind party to admissions of an employee or agent if they have the authority to make such admissions, and this is primarily in Rural Hotels 1973, and this includes managers. Vicarious admissions applies in both civil and criminal cases under the Uniform Act Section 87(1). In criminal cases, admissions made by co-accused or accomplices can bind the accused, and that's Uniform Act Section 87(1)(c). Then you've got the statutory exceptions to hearsay, and this is state. So in the South Australian Courts, Evidence Act 1929 SA Section 34C, exceptions for admissibility of statements in documents for civil cases only. And this includes statements and documents allowed where the maker of document has personal knowledge of matters dealt with in the statement, so that is first-hand hearsay. Statements and documents allowed where, although maker of document doesn't have knowledge, person who supplied maker with that information does have knowledge, and that is second-hand hearsay, provided document is in the nature of a continuous record which its maker is under duty to maintain. Effectively then, prior consistent statements can seem admissible even though at common law it can only go towards the credit when admitted, though note that the judge may preserve the common law by executing discretion to exclude the statement. Evidence Act 1929 Section 45, 45A, 45B apply to both civil and criminal cases regarding genuine documents. Now this includes apparently genuine documents that permit a trial of fact to draw inferences from it can be admitted, so that's Evidence Act Section 34C. Genuine documents of prescribed nature, including bills of lading, passenger tickets relating to transportation and shipments, Evidence Act Section 45, and genuine business documents, Evidence Act Section 45A, which has been now liberally interpreted by Justice Cox and Iron Perry, 1981, whatever degree of hearsay they contain, as Ryan and Etzer No. 2, 1987. Note though, there are extensive discretions to exclude the documents, particularly where the maker of the document can or should be called to testify. Evidence Act Section 34CA, Section 46 to 51, says bankers' books, and Section 59B, computer evidence. So it's admissible generally is the prior inconsistent prior statements of the protected witnesses, including young children and witnesses with mental disability, as hearsay if court is satisfied there is sufficient probative or substantiating value to justify its admission. Now we'll go to the Federal, ACT, New South Wales and Tasmanian courts. So federally, first-hand hearsay exceptions, Uniform Acts, Part 3.2, Division 2. It is defined as previous representation made by a person who had personal knowledge of the asserted fact, and that's Uniform Act Section 62. Then civil cases, Uniform Acts Section 63 and 64, first-hand hearsay generally becomes admissible, although where the witness is unavailable, that's defined in Uniform Acts Part 2, Clause 4, as determinative of, by, including undue expense or delay and reasonable practicality, evidence it is inadmissible subject to notice being given as Uniform Acts Section 67 and 68. Now, where witness is available, evidence is generally admissible, though if a document mustn't be tendered until after the witness has given testimony in chief, that's Uniform Act Section 64.4. The admissibility remains subject to discretionary or exclusion use, and that's Uniform Acts Part 3.11. Now, in criminal cases, first-hand hearsay is more strictly controlled where a witness is unavailable, and that's Uniform Act Section 65. Representation is only admitted in specified circumstances, as with where the common law admits hearsay if the representation was either made under duty to make the representation or representations of that kind, made shortly after asserted fact occurred, and in circumstances which made it unlikely the representation was a fabrication, made in circumstances that made it highly unlikely representation was unreliable, and against the interests of the party who made it at the time it was made. If the representation was made in prior proceedings and the defendant had the opportunity to cross-examine it on that occasion, and where the evidence is adduced by defendant and other party becomes constitutionally entitled to tender first-hand hearsay relating to the same matter, and that's Uniform Act Section 65.8. In these circumstances, representation is admitted. Where witness is available, Uniform Act Section 66. Witness prior statements are generally admissible, but representations must have been made when occurrence of asserted fact was fresh in the witness's memory, and that's Evidence Act Section 66.2a. Now, first-hand assertions of statement of mine are admissible in Uniform Act Section 66a. Now we go to beyond first-hand hearsay exceptions, admissions and representations otherwise admissible. So beyond the first-hand hearsay exceptions in this Uniform Act Part 3.2 Division 3, you got business records. So documents admissible if made reliable as record of business or containing representations made in the course of business, and that's Uniform Act Section 69. Maker of representation, though, must have either had personal knowledge of the asserted fact or direct or indirect supply of knowledge by someone who might reasonably be supposed to have personal knowledge of the asserted fact. Now, these inferences may be drawn from the document itself, and that's Uniform Act Section 183. Representation must relate to the fact rather than the opinion. Representation mustn't have been made in contemplation of a criminal investigation. The absence of representation in a systematic record is evidence the fact did not occur. So this is in the absence. A machine or other devices can be presumed to be reliable if they are used in preparation of those records, and that's Uniform Act Sections 146 and 147. Where reliability of record depends upon credibility of person who hasn't been caught, evidence relevant to that person's credibility may be given. That's Uniform Act Section 108A. So the other exceptions, these include tags, labels, writings attached to objects in the course of business and which describe or state the identity, nature, ownership, destination, origin, weight, or object of the contents. And that's Uniform Act Section 70. And representations about traditional laws or customs of Aboriginal or Torres Strait Islander groups. Representations as to age relationship in Uniform Act Section 73. Existence or nature or extent of public or general right in Uniform Act Section 74. The sender ID, date of transmission or destination from an email, fax, telegram, lettergram, or telex. That's Uniform Act Section 71. Admissions, and that's Uniform Act Section 81 and 87, is per the common law exception rule. Representations otherwise admissible, and this is Uniform Act Section 60, per the prior statements of the witness. Now, at common law, the statements admitted as original evidence, thus not hearsay. Now, under the Uniform Acts, statement is admitted for non-hearsay purposes. In Lean R 1998, the High Court interpreted Uniform Acts not to permit Section 60 to admit other than first-hand hearsay. In response to this decision, Uniform Act Section 62 now states this section applies whether or not the person who made the representation had personal knowledge of the asserted fact. Thus, there can be any degree of hearsay. However, the Uniform Act Section 63 states, however, this section does not apply in criminal proceedings to the evidence of an admission.